Hi everybody, thank you for the warm applause, and I hope I'm not here because I'm the only bad choice you're left with, but because I really do a good job at explaining to you German law, because I know it's not the easiest topic, it's not a fun topic, but I try to make it entertaining enough. Yes, together with the family we launched Legal Straße, and I'm a lawyer at Streiff Law, and we are focused on startups. We're focused on founding them, on growing them, and that's exactly what we're going to talk about. So today is the first part of a series of workshops. We're not going to fit everything into one workshop. We're going to split it up. So we start with founding your GmbH and OG. No worries if you don't know what a GmbH is, what a OG is. I'm going to explain it all to you. Next time, I think we're going to, in a couple of weeks, we're going to do a growing workshop where I'm going to explain to you how it is to grow your startup and you make it legally sound. And later we're going to talk about funding, so getting the money in eventually that you're going to need. All right. Today, founding is laying the foundation of your company. So we see a lot of founders, and it's a lot of fun working with founders because we saw a lot of people already have founded a company, are planning on doing so, are maybe early stage employees. And I really admire that because as a lawyer, we tend to be really risk averse people. You know, you heard Hugo say, well, you know, lawyers don't want to give away the information. And I kind of come from that background. When you study law, everybody's clinging to themselves. And that's totally different from entrepreneurs. You know? So founders tend to be really open-minded. They share ideas, and they are also creating something, and not only applying their skills. And those skills that you need is to envision something. You need to envision a big idea, and that is something like you build a company like a building, and it's gonna shape the future of the society that we live in, because we live in a time where companies are really important. They really have a lot of impact on what we see, what kind of society we live in. And I really want to encourage you to keep on envisioning that and keep building that company, and hopefully with a solid legal base. And that's why we created Legal Straße. I'm going to explain to you all the reasons why Legal Straße is good for you, why you need it, and also how it works, of course. And later about all the details, because we want to found a GmbH, and OG, that's the way to go in Germany. And I'm going to explain you every basic information that you need in order to know what your GmbH, what your company is going to look like. And last but not least, we're going to go into the details of the documents that you're going to work on, so you can use Legal Straße and go from there. All right. All the information all the slides are going to be on SlideShare. There's also going to be a version that is more elaborate. There will be more text on it, so you don't really need to take notes. Also, this is being recorded, so you're going to see it on YouTube and also on legalstrasse.com. So wherever there is the document that you need, and I'm going to talk about it, you will find that relevant information there. So I hope this is going to help you. And if you have questions, we really have a tight schedule. As you see, this doesn't look like a lot, but when you talk about law, you can talk for hours. You know, you could listen for hours. Maybe you don't want to, but we're going to try to fit a lot of information in here today, and that's why we try to keep room for questions in the end. If you have any questions that are relevant to everybody, then please wait until the end, and if not, just send me an email. You can see it here, Daniel at Streiff Law. I'll be also here after the talk if you have any questions that are more personal, or just shoot me an email. And yes, so let's get started. So I love working with startups. And, well, actually, let's put a more positive picture first. So this is the skyline that you're going to build your startups on. And when we envision a startup, you need a solid foundation. And you being the designers, you being the people who envision it, who create a startup, you tend to sometimes forget what could go wrong with a startup. And that's why sometimes it's good to have some legal knowledge, some infrastructure, to have a solid foundation, not to build on sand, not to build on toxic ground. We heard about toxicity. So you need to kind of be aware that there are some things that you have to take in mind before you start the founding of the company. Because if you found on sand, there is nothing you can do. Sometimes you have to rebuild the whole thing. And I think as a lawyer, we tend to be really critical, which is in a way a good thing. You know, if you only spend time with lawyers, that's a bad thing. You tend to be really negative overall. But working with founders, I think there is a good balance. And when you look at the company like a building, then the lawyers could be thought of the guys who take care of the statics. So everything stays stable. You can build up high. And the structural engineers, if you want. So this is what you should think about when I'm going to talk, when you listen to this. And what we find a lot of times is that everybody knows the statistics. 9 out of 10 startups fail. As you heard from Hugo, in the family it's a little less. So they really turned around the statistics a little bit, and that's what we're going to work on. And I believe that a lot of times it's because that foundation was not right. There is a lot of people just start building and they didn't think with the end in mind. So let's turn this around. This is our mission here with Legal Straße, and we want to give you a new hope. We want to turn around that number and empower you, like Hugo said, through legal infrastructure and legal knowledge. What does infrastructure mean? Infrastructure are the contracts that we provide for you. So you will have something to work on. And how do you work on it? With knowledge. Because if you just have an infrastructure in place, you don't know how to use it, then it's pretty much worthless. So the same goes if you pay for a lawyer and he's going to give it every detailed information to you and you're just not going to apply it, then it's worthless. So this is a workshop. You have to work by mostly remembering what I say. All right. One of the reasons why you should use Legal Straße is to avoid the pitfalls. I mentioned it, there are some things that can go wrong, and especially in the beginning, your startup is really fragile. And if the beginning is wrong, then everything, will fall apart. There are other cases where you make a mistake in the beginning, it's really tiny, there's a tiny crack in your foundation, and then after years it will show, it will grow and will become really disastrous. So, and ironically, this is only for those startups who become successful. They grow and they have a really big building and it's all looking shiny, but there is this one big little mistake in the beginning that really shows after years. And so these are two things that you want to avoid. And through those workshops, we're going to show you all the major pitfalls that you can avoid. Second, more bootstrapping. Hugo mentioned it, especially in Berlin, in Germany, there's a lot of funding at a very early stage. And bootstrapping means that you do it yourself. So you try to spend as little money doing as much yourself as you can. And this used to be really rare, and that's why a lot of people say, well, you don't need to professionalize. You don't need all that knowledge, because back in the day, you started getting an investor, and that investor would give you your term sheet, the articles of association, and then you would just go with it. And even on this stage, people said, well, why should you bother about all this legal stuff? Just get some things right and then you're fine. But I disagree. We live in a time where you can bootstrap much longer. There is so much open source software out there, so much community, so much help between you guys, and that's why you can make it much longer. And the reason you should do so is so you should stay in control. So you keep the power, you keep your hand on everything that happens, because it's your vision and you want to stay with it. So third, bring balance to the force. So this is supposed to be a lightsaber. You cannot really get any open source Star Wars pictures. Anyways, the force. There is an imbalance that I see, because as you all know, startups don't have money, and the big competitors do have the money, and also investors have the money. And in Germany, there is regulation. So there are a lot of reasons why you are the underdog. And we want to reverse that trend. We don't only want you to live and survive and then make it to an investor. We want you to be on I side with the investor. We want you to have the power, the negotiation power. And let's say you go to an investor for an investment round after a year, after two, and you already have a good system in place, a good legal system in place, then you can negotiate with him. You understand what you're talking about, and he cannot just impose to you like a gift, this nice term sheet, and you have to accept it because there's nothing else that you have. So you want to be founders that really think it through till the end and bring back the balance to the force. So that's my wish for you. All right, and last but not least, it's free. So, well, that's why you're here. Okay. Second, how does Legalstraße work? Legalstraße is just a website. It's really simple. You go to legalstraße.com. That's what you're gonna see. So this is starting the homepage, and you see a list of documents, and it starts with the Articles of Association, Shareholders Agreement, and so on. And those are the documents that we're gonna talk today about. So those are the founding documents, and when you want to use them, just select them, download them, and then you will have to do some work, and that's why we're doing the workshop, so you know what you have to fill out, because there are some passages that are marked in yellow or in green, and there is a comment in English next to it. So the comment shows you, well, this is about, let's say, just the name of the company, and this is what you should put in. And you can comment back if you have any questions, or you can mark document comment, but please don't comment your personal information because it's visible to everyone. You know, we can use this as an open source, kind of like a community platform, but you know, if once you downloaded it, you fill it out, your information, but don't, you know, put it on the internet. All right, we'll start off with the Articles of Association, Shareholders Agreement, and the Managing Director contract. And they are all designed for GmbHs and UGs. And this is what I'm going to explain. Oh, actually, this is the marked passages here. So you see it's yellow, and then on the right-hand side, there's the comments. Okay, but Articles of Association, designed for GmbH and UG. And this is what we're going to talk about now. So, time for a German lesson. GmbH stands for Gesellschaft mit beschränkter Haftung. And UG is short for Unternehmergesellschaft. And then always get this is typical German, as you know. So there are long words. In the brackets is Haftungsbeschränkt. And this is the full name of it. And you have to call it UG Haftungsbeschränkt. Really important. So what is a Gesellschaft? Because you see it's the same G in both abbreviations. And a Gesellschaft is just a bunch of founders joining together. So it's a partnership. When you work together and do something, it's a Gesellschaft. Why would people do that? Because they can create a common goal. They can work on something together. This is like a really personal bond. They're all tied together, and so they all have to work together. So they run this Gesellschaft, this partnership, and this got advantages and disadvantages. There are two disadvantages that I want to talk about. One is that all of them are personally liable, 100%. So when the partnership starts having debts and a creditor comes, it can go to any one of them, and they will have to pay with all of their money, so until they're bankrupt. So it's really important to stress that. You don't just want to do a Gesellschaft. You just don't want to go around. That's why we do the founding. Second, it highly depends. The partnership highly depends on the people. So only they are allowed to run it, and only they are the ones who can take part in it. So when there is someone trying to leave the company, or he dies, something happens, then the whole partnership dissolves. And that's not something that you want to envision. Like, you think of your skyscraper, it's not something that depends on every single person involved. So that's why you create a GmbH or a UG. You see, it's like a person. It's only got a different hat, a money hat. And the reason it's a person, that in the eye of the law, we know such things as legal person. And it's not a human, you know, it's a company that has an own personality, sort of to speak. And I really want you to think about it as a person. So it's born, it can die, and it's got a whole life cycle to it. And the reason you want to have that, it's independent of its founders. So whenever you try to, one leaves the company, you still have that entity, and it can still act like everyone else, like another company. And in order to act, it needs managing directors. So this is a person that doesn't have to be one of the shareholders, like compared to the partnership. You have CEO. German GmbH doesn't have CEOs, it has managing directors, and these are the guys running the company. So this could be someone else, because back in 7 years from now, when your company is really running high, you don't want to do the managing. You know, you let someone else do it, and that's why it's good to have a GmbH or OG. All right, and now the main advantage or the disadvantage of the partnership, you don't want the liability, and that's what beschränkte Haftung means, haftungsbeschränkt, limited liability. So this company is liable itself. It's not you as the founders, it's the company. And so when the company has debts and goes bankrupt, then there is no way you can get touched by it. So you limit your risk. That's actually the main reason people want to found it. How is it liable? It is liable with the share capital that you put in. So you see here on the right-hand side, the shareholders put money into the GmbH, and this is the reason why there is such an entity. So think of the GmbH as a person that is a pile of money. So and this pile of money is the reason it can go around and do business. All right. So why should you found one? To wrap up, it's got limited liability. It's an entity that's independent of its members, of the shareholders, and it is publicly accepted. In Germany, it's been around for many, many years, and also the UG has been around for 10 years and starts to be more and more successful. And the reason it's publicly accepted is that there is a public register for it. So the public knows about it. All the information is out there. So it's not like you just make up a company. There is a register. Okay, what is the difference between a GmbH and a UG? The main difference I want to stretch that is the name. It is really the same thing. The only reason they have a different name is that the share capital is different. When you used to have 10 years ago, you only used to have GmbHs, and people founded a lot of UK limited companies because UK limited were possible with £1. And the GmbH had to put in 25,000 euros. And that's why Germany wanted to compete with the UK, and they established the UG. And you only have a minimum share capital of €1. If you have more than 25,000 or 25,000, it's a GmbH automatically. Okay? So other than that, it's the same thing. So here the money, that's the difference. But it's the same concept, it's the same bodies, and that's why the Articles of Association are the same document. You just have to choose your share capital. All right. Also, the UG needs to be paid in cash, and if you have a GmbH, you can put in your car or your whatever, your real estate that you have. That could be your share capital as well, your assets. Okay. So what should you choose? My advice, choose the UG. If you don't want to invest more than, or if you don't want to invest 25,000 euros, because there is no real difference to it. If you need that money, the company needs to work with 25,000 euros or more, then go ahead and put it in at the beginning, because it's not like the money is going to appear from nowhere. So if you have the money and you need it, put it in. But if you don't, just go for the UG. The only reason, maybe if you work in a really conservative environment, maybe they will frown upon the UG. So it's just not a real company. But the GmbH is not that different from it. Another case, or another reason why you should go for the UG is you can upgrade it anytime. So whenever you have the money, later on, you can just put in share capital, raise it, and once it's above 25,000 euros, it will be a GmbH automatically. And when you make profits with your UG, you have to retain 25%. And these 25% over years can add up to 25,000, and you will have it automatically. All right. Third point, if you have a founder holding, if we have time in the end, maybe we'll talk about it, but you should go for an UG, because it's really unlikely that you need more than 25,000 euros for that. Okay, next question. When should you found your UG or your GmbH? very soon and much sooner than most people expect. The moment you found your co-founders and you developed your idea and you know that you want to make business, that's when I would start creating the GmbH und UG. You should definitely do it before you create any intellectual property. Intellectual property is such software, a logo, design, prototypes that you develop. So this is one of the most common mistakes, I would say, and one of those pitfalls that I want to warn you about, that people start creating IP and they do business and then eventually decide on founding a GmbH or UG. Why does that matter? Because the moment you do that business, the moment you create IP, you automatically founded a partnership. Remember the partnership? The partnership is the one where you're all liable and where everybody, like, it depends on who's in it. And so this happens automatically. You don't need a contract. You don't need to sign anything. So the moment you guys kind of agreed, said, well, let's work together, let's try it out, then you started a GBR partnership. And this can get really, really messy. These are some of the risks that you have here. It's really expensive to transfer the IP that you built to the GmbH because people realize they don't want to stay in a GmbH forever because you're 100% liable, and for all the other reasons. You don't have a contract. You don't have agreed on anything, so it's all the law that applies. So kind of German law decided, well, there must be some things, so there is certain paragraphs that apply to you, even though you didn't agree on anything at all. Just, let's work together. So it can get really expensive, and that's when the lawyers get into play, and that's when the accountants get into play. They hate the work too, it's messy, but they like writing the bills. So taxes. So when you transfer your IP or anything that you created with your partnership to the GmbH, it needs to be at a price. You need to evaluate that, and that's where the tax accountants come into play. And if that is not correct, then after years, or maybe in that year, the tax authorities can come back to you and charge you with taxes. Say, well, this was kind of a gift, it was too cheap what you evaluated. It was worth much more. And this is one of the cases where a really successful company can be the one that is suffering from a really early mistake. So if your company dissolves after a year, no one cares. The tax authorities don't care. They get nothing. But if your company becomes a multi-million-dollar or euro company, then it will the tax authorities will really like to get taxes from that. And that's only the cases where your founders all work together. So what happens if you decide to kick one of the co-founders out, or one of the co-founders doesn't want to work anymore in the GmbH? Then he can pretty much blackmail you. You have to buy his share, because he can stop you from using the IP that all of you started creating together. And he can charge either license fee from you, or he can just block you from doing so. So your company depends on that. And that is a really risky situation. And even if you can buy him off, say, pay him an amount of money, he signs something, some release paper, then still, if once you get an investor into play, or another founder wants to join, he will look into the company history, and you have to do some due diligence, and you have to guarantee that you didn't, there was no mess in play when you started the company. So they will decrease the valuation of your company. They will see that risk, and they don't want to bury it. That's who you want. You are the ones who have to bury that risk. All right. Here we have the steps on how to found a GmbH UG. We just covered the GbR. This is the red part, risky. You don't want that. To the right-hand side, this is our goal, the GmbH. There is something in between, and we're going to talk about that. But like I told you, you should think of the GmbH or the UG like a person, and it has a life cycle, so it's being born. And so you have to think of all the steps that you need to take in order to get the company born. And the first step is the dating. You, as the co-founders meet, you develop an idea, you want to agree on, how do you want a baby together? Do you want to really get involved with one another? And like I told you, don't do anything more. Don't live in a wild marriage, so to speak. Go to get the contracts right away. Because after you've developed your business, you don't want to create anything that is worth before you signed it. So what is the next step? Anyone? Paperwork, yes. And in the analogy of getting a baby, you have to have a marriage. In Germany, law very conservative. You need a marriage. I mean, not you figuratively. It's a figurative, a metaphorical thing. So you go to the notary, and that's when, just like a real German wedding, it's really a lot of reading out loud and a lot of signing. It's not really romantic. But it needs to be done, and that's what you want to happen. Because the moment you went to the notary and signed all the founding documents that we're talking today about, the moment you have a pre-GmbH. So this is liability-wise, it's better. But you're still not right there. The next step, how do you get the baby? All right, I think all you know. So the next thing is intercourse. I refer to it. So, like I told you, the GmbH is a baby of money. It's a pile of money, and that's why the action that takes place is putting the money into the bank account. So that is when it's fertilized, when you start to be pregnant with the company. And so what you need to do next, and this can you can go right from the notary. Like in a real marriage, you can consummate the marriage right away, but you can wait too. So there is no rush. But of course, you want your GmbH as fast as possible, and if you want to, you can make an appointment with a bank right on that day. If you want, just email me or Hugo, and we have some banks in Berlin that do it right away. So what you do, you open the account. Don't forget your firm's name on the mailbox, because you need an address in Germany. You can be all foreigners coming from everywhere, but you need one address in Germany, and that's where you should put the mailbox, your whatever company name, so they can send you the documents, the banking documents, and you pay in the share capital. So that's the fertilization. And once you did that, you notify the notary, and he's going to apply to the commercial register for you, because the commercial register is the one that is helping you get the birth. So once your company is in the commercial register, that's when you can celebrate. It's like a bureaucrat's fantasy of birth, maybe. It's really, there is nothing much to be done. So you just realize one day you click on commercial register and you see that your company's in there. So not a lot of not really exciting. The only things that you should pay in that pre-GmbH phase is the commercial register and the notary. And don't pay anything else, because you're going to be liable for it and it's going to be messy. So you have to wait to really do business until you are entered into there. Okay, and now is the most boring part, because when you have a kid, you have to do all the errands, food to any administration. You have to get applied to kindergarten, and I think in Prenzlauer Berg here they have to do it even before it's born, so you really get it in time. So you have to do all those administration stuff, and the same goes for your company. So say again. Diaper. Yeah, there's a lot of diaper filling involved. So the first thing you have to do is you have to register your company as a trade organization. It costs 30 euros, and normally it's not a big deal. But we will cover that later. Sometimes there can be some issues. Next, the Finanzamt is going to talk to you. The Finanzamt is the tax authority here in Berlin, and you will have to fill out a form. They already know that you founded the company because the notary told them. So whatever you notarize, the Finanzamt knows, just so you know. And you have to do your monthly VAT. So once you have your VAT number, you do the VAT declaration, and that's the second thing. Someone also who's writing you a mail is the commercial chamber, IHK. They just got to charge 80 euro from you for being a member. And the last, which I really want to stretch, is the DRV. We're going to talk about that later on, one of the last things. The DRV is the Deutsche Rentenversicherung, the German pension insurance. And as a managing director, I told you the guys running the GmbH, you should do a status check on that, especially if you get paid. I'm going to talk about that later. But keep that in mind when you have all the founding errands that you have to do. Okay, now we know how to found it, and let's go into the detail of the documents. This is the Legalstraße homepage again, and these are the 3 documents that we're going to talk about. So we start off with the Articles of Association. That's the company's constitution, the most important document. You have to have it, and it is in the commercial register. It is public information. And what does it contain? Like ID card or a passport, it contains the basic information about the company. You think of it as a person. So what does it have? What's his name? What's the address? When is it born? Those things. They are all in the commercial commercial register because it's in the Articles of Association. All right. Also, it contains the organization, and that means how all the bodies of the GmbH work together. Who's responsible for what? And you already know the bodies. It's the shareholders meeting, it's kind of the owners, and the managing directors, the ones who run the company properly. So what are the main issues in the Articles of Association? First, shares. This is something where no one really can help you with. I told you about what your share capital should be. It should be at least, I would say at least 1,000 euros. So I told you that the UG has a minimum of €1, but also the founding costs at least 800 euros, something like that. So if you have to pay for it anyways, make a share capital of at least 1,000 euro, so the company can bear its own costs. Because if you don't do that, if you have only like 5 euros in the share capital, then you have to bear it, and you cannot get it back from taxes. But the company can. So have at least 1,000 euros, and now it's up to you to decide how to distribute them. So, well, if everybody's putting in the same work, you're 3 founders, you typically go for 33%. But, a lot of times one of you came up with the idea, and there is no magic formula for that. But we will have some ways in order to cover your risk with that, but not in the articles yet. Second, the name. So when you think of your skyscraper, don't call it Trump Tower. It's gonna like the owner's gonna grab you. He's not gonna be lightly about it. And don't call it Trump Tower too, because it's a similar name. So, and that is a tricky part, because you find out really easily if your name is taken yet. You just Google it, but or you go into the HR, the register, or you do this trademark check at WIPO. You see a link there. But you have to keep in mind that there is competitors of yours who could have a similar name, and they have registered trademarks, and you cannot just use that, even though it's not the same. But it's not allowed, and it would be a pity if you started your company and bought your domain, the logo, everything, and then you realize the name is taken already, or you cannot use it, and this happens. Third, and this is again a reddish box, which means it's really one of the pitfalls you can fall into. Regulation. Because of the object of the company. The object of the company means what does it do. So an online shop is an online shop, and a manufacturer of, toys is a toy manufacturer. So you just have to translate it into German, but you want to keep it rather wide so your company can expand, because you're going to pivot a lot. And like I told you, you want to found rather early before you really know if your business is going to work. So keep it wide, and that shouldn't be an issue. I mean, if you have a competitor, just go to the address, the Bitly address here, and you will find out what his object is, and you can orient yourself with that. But the issue comes when you do something that is either illegal or you need a permit for it. And that is something that you may only realize when you draft your homepage and your articles, your terms and conditions, the AGB. So you should really pay attention whether what you do is allowed and if you have all the required permits for it. And you may need professional assistance for that. So there are some cases, especially if about payment. So if you take let's say you're a platform and you take the buyer's money and you give it some back to the seller and you retain your commission. If you do that, then you need a permit, you need a banking license. And, well, there are some payment providers out there. If they have a license, you're fine with it. But remember that if you do something that you're not allowed to do, if you don't have the permit, then any competitor can shut you down immediately. So he can file an injunction, and the court will just sign it, and they will stop you from doing business. It's going to be really costly. Also, I mean, it's possible that the administration is going to be faster than the competitors. Maybe not too likely, but the administration could see, oh, well, they're doing that. They read in the papers or something, and they will come to you and they'll ask you, well, do you have a permit? Or they know that you don't have one, and they can stop you from doing that and going to fine you, and it's going to be expensive. So the banking license is one of the classic examples. Online shops do it all the time. They mess up with it. Also, if you're an agent, if you're mitigating contracts between others and you take a commission, a lot of times you need a permit. Also, insurances, when you do with insurances, when you do with anything that has some health issue, or there are some professions that are protected, like my profession, lawyer. You cannot just do legal stuff out there. I couldn't even found a game behind do that myself. So that is forbidden too. And or taxis. You cannot compete with the taxi industry just like that. You need a permit. So pay attention to that. These are the main AOA issues. And now let's talk about the shareholders agreement. Shareholders agreement is an agreement between shareholders. It's not too hard. The difference between the Articles of Association and the shareholders agreement is it's only between the shareholders. Before the articles you saw are for all the bodies. It's the constitution. The shareholders agreement is something that you can secretly agree on, keeping in mind that the Finanzamt, the tax authority, is let into the secret if you notarize it. Because you should notarize it and have the highest form that is possible in the private law, because it relates highly to the Articles of Association. So if you want to save money, put all the clauses that we put in the shareholders agreement into the Articles of Association, but they're going to be public. And sometimes you don't want the sensitive data to be public. So it's up to you. You have to pay for your privacy, so to speak. What do you put in the shareholders agreement? All critical clauses, and we have included them all in the templates. Again, you see it's red meaning, oh, it's important. So if you mess that up, this would be one of the cases where you will regret it later on, really big time. Because as shareholders, you want to stay together. You don't want anyone to come into the company or leave the company not working properly, and so you want to kind of have a hold on that, or you don't want your fellow shareholders, fellow co-founders to screw you up and work for a competitor or something. This is why you have non-competition clauses. This is why you have vesting, and when you sell the company, you want to sell it together. So this is why there are drag-along rights, tag-along rights. So the reason you should, in my opinion, put it up from the very beginning is you cannot do it afterwards if not everybody agrees. So if you agree from you have to think with the end in mind. You agree from the start, then you don't have to think about it later, and you don't have to, let's say, buy someone off. Let's talk a lot about in detail more about vesting. Vesting is the most important clause, I would say, because it makes sure that all the founders work together in the company, and none is just sitting back and doing nothing. What does it mean? It means that you have to return your shares if you stop working for the company within a certain period of time. That is the vesting period. Typically, it's maybe 4 years, it's 3 years, 5 years, but let's say 4. And what does it means stopping to work. Stop working means you either resign. Let's say you are the managing director and you say, I quit, screw you, you leave, or the company fires you. And you want to make sure that the company cannot just fire you for any reason, because in the scenario with 3 founders, you have 67% against you, and they could fire you right away if they wanted to, unless you use our templates, of course. And in the templates, we only allowed firing for good cause. So this is something that would be allowed if you don't put it in a contract. Also, if you just sit back and refuse to work, that's also constitute reason for vesting. Stop working. There is one thing, and we'll see it in the graph. During the first 12 months, which would be the cliff period, you would have to return all of your shares if you stop working within that period. That's optional, but it's typically in the contracts, because if someone leaves that early, he didn't really contribute anything, and you don't want to have him as a shareholder anymore. But after a year or so, people say, okay, you stay shareholder. He doesn't have any voting rights anymore. He just, gets the profits that he earned so far, but he will get to keep at least 25% of the shares. And after the vesting period, when you leave, you're free to go. You just keep your shares. So that's the deal. Now, managing directors. We just covered briefly about being fired as a managing director. And what the managing director does is, in German, Geschäftsführer, so that's the synonymous. And there is no such thing as a CEO in Germany. Anyone on LinkedIn can say, I'm the CEO, but it's not protected, But Geschäftsführer, it's public information, it's in the commercial register, so you cannot just say you are. The managing director manages the company and he represents it. Managing is more of the internal part, so he's dealing with employees, he's doing the accounting, he's doing the taxes and everything, and whenever he deals with someone outside of the company, he represents it. So when you sign a contract, when you write an email, when you set anything up, or anything that a person has to do, a human has to do, and that's why the managing director needs to be a human. The reason for that is simple. The GmbH is not a human. We treat it like a person, but it needs kind of arms and a mouth in order to work in this world, and that's what we have the managing director for. Managing director sounds cool to be, but there are a lot of risks that have to do with this, with the orders that he can receive. So the relationship with the company is basically fairly easy. He has the contract, he's working for the company, and he's also representing the company. But the shareholders can give him orders. And this is going to be relevant in a second with liability. This is one of the things people are not aware of. You think, I'm the managing director, I rule, this is my company. But what you fail to realize is that whatever mistake you make, whatever damage you cause to the company can claim it back from you. So when you make a mistake, a business mistake, and it causes damage of 100,000 euros, you pay for that if the company wants you to. So it would be wise to be a shareholder in the company that has more than 50%, because in that case, the shareholder would not charge you with 100,000 euros. But that kind of shows you the risk that you are in. As long as everybody's cool with one another, all 3 shareholders or all 3 managing directors, we're all into this together, we made a mistake, then it's fine. But once there is a conflict, it can be that you get charged by the company. And especially when it goes downhill, when the company goes bankrupt, then you will not be the managing director anymore. There will be, if the company still has some assets, there will be an insolvency administrator, Insolvenzverwalter, and he will take your place, and he will not care about whether or not you are a good managing director or not. He will try to do the best thing for the company, which is getting money, and he will try to get the money back from you. So this is why in our templates we used a lot of clauses to limit your liability. So you're only liable for gross intent, for gross negligence and intent. And there is a lapse time, so you cannot infinitely be charged with that. And also, you should take care that at each financial statement, every time you have to do your taxes and the balance sheet and everything, that you get released from all charges, from all claims by the company. So this is kind of standard procedure, but don't forget about it. I told you about the orders that the shareholder meetings can give you, and this is on one hand a good thing, on the other a bad thing. A good thing because you can release yourself from that responsibility too, because as a managing director, the shareholders can tell you anything, how to run the company. And when they do, it's not your problem anymore. You just shouldn't break the law. That's just because you should always respect the law. But in that case, it's also a way, when there is a hard decision, get a shareholders resolution. Have them tell you to do that. Second, social status. Often overlooked is the question whether the managing director is an employee of the company or he's self-employed. And ask any managing director out there, he will always feel like he's in charge. He's self-employed, selbstständig. But reality, because of that order thing, the shareholders can always tell you what to do. The courts and the German pension fund, the Deutsche Rentenversicherung, they feel like you are an employee if you don't have 50% or you cannot block any of those orders. So most of the managing directors out there are in fact employees. And why does that matter? Because you have to pay wage tax, you have to pay social insurance contributions. And if you don't clarify that, people in the beginning, when you get compensation, you have to live off something. Let's say you get 1,000 euros or maybe 2,000 euros per month as a compensation. This will add up over time, over years. And I had a case recently where over 100,000 euros of pension insurance and late fees accumulated over a couple of years, only 3 years or so. So the late fees really can bite you back. And this is one of the cases when the company is doing well, you make a lot of money, but you forget about, those basics, then it can be so costly for the company. And we will talk a lot more next time in the workshop about the issue of being employed or self-employed, because it makes a big difference for freelancers and employees. So what should you do? To clarify, you go do the status check with the German pension fund, and if you do it within 1 month after the notarization, after the wedding, then you will get some benefits. You will know for sure very early. You can still change your contract. So if you have a negative veto or verdict by the Deutsche Rentenversicherung, you just write me an email, and there are some things you can do. And also, you will know. You could start off with no compensation at all. That's in the beginning you don't have money, but then you still do the status check, and they will still tell you. So there is no risk involved. All right. Last but not least, and this is the most brutal one, it's public obligations. So I told you about the internal liability here on the left-hand side. So whatever you do as a managing director, no one can touch you. Like non-creditors can come to you and charge you for anything that the company owes to him. But the company could, in theory, at least claim anything back from you. That's internal. But the reason for the GmbH being, a limited liability company is that there is always someone to blame, and that's the managing director. So that's why I say that it's not really desirable to be a managing director, but as a founder you have to man up to it and you have to do it, It is nothing you can really, you have to do your job properly here. So any obligation that the GmbH has, you have to fulfill properly. You have to pay your taxes, you have to do the accounting, you have to deduct the wages for the employees. We're going to talk about that next time. And you have to file bankruptcy if everything went downhill. So if you don't, then you can go to jail. So people wanting to be managing director should think about that sometime. But then again, you have to know all these things. You have to have the legal knowledge. You have to work properly. And if you do, then nothing's going to happen. All right. Those are the main issues. I think we covered pretty much everything. We covered the articles, we covered the shareholder agreement, and we covered the managing director contract. And that would be everything from my side. Next time, we're going to talk about growing a company, a lot of things that have to do with the managing director that we covered already, about hiring people, hiring freelancers, about protecting your IP, something that we scratched before, and also about employee participation, so you can incentivize your employees. All right. Thank you so much for listening, for being patient. Thank you. Yeah, so if you have any questions that are relevant to everyone, please go ahead and just ask. If not, you can always shoot me an email, or I'll be here afterwards as well.
I just wanted to know, is there any liability difference between UG and GmbH?
No, I mean, like Hugo was saying before that he was very proud of me of never saying it depends. Now I have to say it depends. But actually, like I said, the UG and the GmbH is the same thing. The only difference in liability would be that, let's say, you have to use the name UG haftungsbeschränkt. You know, you as a GmbH, you just don't have to do it because it's not your name. But no, of course, like when you have an UG, let's say you have 1,000 euros in share capital and you already spent 500 of it, you have to call in all the shareholders. You have to have a shareholders meeting saying, "Oh, we spent half." That's the only difference, I think. And of course, if you don't have money, you're gonna be bankrupt sooner. So, but that's.
I have a question, and with my potential co-founders, we had a debate on the decision-making mechanics. And then, in the respect of articles of association and the shareholders agreement, would you see that in any of these two, say, constitutions or contracts between the co-founders? You know, you could have like the MD always makes the decision, or there's a consensus, or there's a majority vote, or how, you know, I'm just curious to hear your experiences and recommendations on that part.
Yeah, so this follows under organization from my perspective. It's typically you have to have some clauses about which majorities go for what, and what is the managing director allowed to do without the consent of the shareholders, or where can they the shareholders even give him some orders, and where he's free to go. So I would include that in the articles. I mean, you can modify that in the shareholders agreement if it's something that is kind of unusual, because let's say one person wants to be in charge at all time. Maybe it's something that shouldn't be public information. And so, but there is, whatever you agree on inside the Articles of Association is binding before everything else. But let's say you could ask the others for damages if they don't follow what's written in the shareholders agreement. So if what is in the Articles of Association is the Constitution, what is in the shareholders agreement, you can kind of charge them. They didn't follow your lead, and that's why there are consequences. You could agree that in the shareholders agreement, but I don't see most of the times why you shouldn't go for the Articles of Association.
What about the holdings? If I have a holding and there's
Yeah, well, I think I mentioned it before. That's what I wanted to cover as last, so that's a good thing. So a holding is it's the Russian doll situation. Everybody knows a Russian doll? This thing here. So there is a doll inside a doll, and it's getting smaller and smaller. So it's the same thing with companies. So you can have a small UG that only has one shareholder, and he owns that UG. And this UG, again, is the shareholder within the operating GmbH. And so you have company inside a company. And I would refer to that UG as a holding, even though that's not the legal term. Call it investment company, whatever. But in my understanding, I would say it's a holding. And the reason why people do that is because it saves taxes. So you see the other two shareholders are humans, and when the operating GmbH makes profits, then you as a shareholder have to, do your taxes, and you pay between 25 and 40% of taxes, but not the UG. The UG has a privilege, and if it reinvests that money, so if you're a serial entrepreneur and not being an entrepreneur with a GbR partnership and then GmbHs, several GmbHs, you can reinvest that money and only pay 5% in taxes. So this is high and a big advantage of it. And also you can deduct business expenses. So this UG can, lower its profits, and so this is something you cannot really do otherwise. And one advantage of founding such a UG is that you can just use the standard form. So I talked about the Articles of Association and how there are so many clauses and of what you can put into the shareholders agreement. But if you're just the only person, you are 100% shareholder, you are the managing director, you don't need to agree on anything because it's all you, So you can just use the standard form. The standard form is a cheaper cheap foundation of the UG or a GmbH. But if you're more than one person, don't do it, because all the critical clauses that we talked about vesting and everything else, is not included in the standard form. So just do it if you go for a solo founder. And yeah.
Regarding the Articles of Association, if you want to change certain things in the shareholders agreement, is it possible? Let's say voting rights, or if you want to have a shareholder meeting, you need more than 75% to attend. Can you change that to 50% or 51% in the shareholder agreement?
Yeah, I think that goes hand in hand what this guy said. You could. I would just do all the organizational stuff. I would keep it in the Articles of Association, unless there is a good reason why you want that to be private, why you want to have it in secret. So what the law says is, when you make decisions as a shareholders meeting, it's just a majority of votes. So if you have more than 50%, that's where we go. So if you have 3 founders, 2 can always overrule 1. But a lot of times you don't want that. And especially when it comes to important decisions. And you can just agree that you have to be anonymous, have 100%, or have at least 70% of majorities. And that's what you should do if you feel it's important. You just have to make sure when you change the majorities that your company sometimes can be at a deadlock. Because if any decision can only be made anonymously by all of the shareholders, then you will maybe not make any decision anymore, So I would maybe restrict it to important decisions, but there is a good reason why you can do that, because if you have that veto right, so if you have the power to block any decision, then as a managing director you will be self-employed. So what I talked about before. Self-employment meaning, not paying social insurance, being your own boss. So you don't have to have 50% in shares, you can have a veto right like that.
Can you put anything else than money into the company, like, for instance, shares of another UG?
Yes, you can put any assets in a GmbH, but you can only put cash in a UG. So, typically, it's hard to evaluate the value of other companies' shares. And I don't know if you're allowed to do so for the, just... Because in my contracts, I would not allow to put your shares into another company, but it depends on the one that you put in. But it could only go for a GmbH. UG always has to be cash.
This is actually a comment about a mistake that I made with the holding company, which is that if you're not a German citizen, I guess it's worth checking with how the taxes work in your home country, because I'm an American and I set one of these up, and the American tax authorities still need all of the taxes from you, and so you would have to take the taxes. I would have had to take the taxes out in order to pay them, which then would have triggered the German taxes. And when you have one of these things, you then also have to submit to the German government balance sheets and you have these liabilities, and it's complicated and expensive to shut the thing down. So anyway, if you're not a German, just understand how your local taxes work with that too.
I heard that it's very expensive to make the transition from UG to GmbH. Is that true, or?
Well, no. I mean, when you when you raise the share capital, you have to pay the notary, and you have to pay the money that the share capital has to be raised. But it's a standard notary fee depending on the amount that you put in. Of course, if you have the money from the start and you need the money, put it in and don't do the raising afterwards. It's it's not necessary. But if you don't have it in the beginning, then I don't see. I think it's worth it waiting.
So if you're European, can you open a company here in Germany and live in your native country?
Yes.
Is it legal?
Yeah. You can be from anywhere, and you can be even the managing director. You can be the manager of the company. I mean, I'm not sure if you're allowed to work in Germany where if you have a permit for doing so, but no one will care. No one will check when you found it. Of course, after when you do your taxes, maybe you should clarify that beforehand. But the only thing that you need is a company address in Germany. And that's where you have the mailbox, and you need to check your mail. Maybe this guy? No?
I'd ask you, just related to that question, and you mentioned people studying.
Yeah, so I'll repeat the question. It was whether you are a resident of Germany, you can found a company abroad, and especially because German companies have a lot of regulation and there's a lot of diapers changing, so to speak. Actually, I'm not really sure about other legal, how other countries deal with it. I'm pretty sure that within the European Union, it has to be allowed because it's just all the basic freedoms that we have within the European Union. I just don't know what their requirements are because it should be similar to Germany, but I have no idea. And I would not recommend doing a UK limited now since the Brexit kind of came along. So, yes.
Actually, it's a comment. It's advice for those who are looking for additional legal checks for the websites because, as I understand, Streiff Law, looking at their website, they concentrate on contractual things. But of course, if you're running a UG or a GmbH, as I am doing, you want to have legal checks for your website as well, privacy policy, cookie policy, and so forth. And from next year, there will be not a directive, but a regulation from Brussels, which will be as obligatory for all EU countries. So, to make it short, I discovered a service that provides not just checks for privacy policy and cookie policy, but also has a very good system, a server that automatically updates all the checks when there's changes in the law.
Ubenda?
Ubenda, yes.
Yeah.
Yeah.
Right.
You know about them as well?
Yeah, they're really good.
Yeah. And they have in different languages as well, because if you're a website in Germany, you're not just addressing German users, but also users in other countries. So it's important to comply with your target countries, not just Germany. But I don't want to steal your show, but I just wanted to add for those who are interested. In fact, I'm the contact person for Ubenda in Germany.
All right. Okay. Well, thanks for that. I know Ubenda. One of my clients used it recently and they're really happy with it. And
it's free.
And something you mentioned was something I want to comment on, that you have all this regulation in Germany, and especially consumer protection. And that's not only a German thing, it's a European thing. So if you want to escape that, then you have to go outside the European Union, because the trend is that there is more and more unification. The consumer protection becomes more and more the same. So, yeah.
I'm just wondering if you can speak a little bit more on some of the pitfalls a foreign founder might come into, as opposed to sort of being a German or European citizen?
Yeah, so basically, I think it's just the understanding of how it works here. About a lot, where we have the most difficulties. One of my clients, I drafted the TLCs, the AGB, and the most difficulty they had was the regulation, to understand why we regulate so much. Of course, I'll take out the consumer protection, but there is so many things that are just cannot be apprehended by foreigners, why we have to regulate it. Other than that, I mean, you're free to found a company. You just have a little bit more you have to do the translations a lot of time. So you have documents that need to be translated, and it's kind of have to be a notarized translation. It's a little bit more work, extra work, and also when you want to, in Germany you always have to have a German version of what you decide. So that's why the contracts are in German. They have to be. And if you want to have a translation, then it's just for convenience too. And something I mentioned, if you're a EU citizen, there shouldn't be a lot of trouble with whatever you do. And I think the most trouble you have is with taxation, because a friend of mine, she's from Austria, and it's really hard to do taxes in two countries. I don't know. I don't know any good solution for that. Thank you.
Que la famille